I didn't understand what you were telling me. Come back up, man.
Yeah,
You were trying to get them all together, correct?
Yes, it's possible. I did speak to. I did understand if you can't get them on the docket tomorrow with such short notice, and we did speak about that. Correct, Ms. Byers?
Correct, yeah.
I mean, I will set them. I mean, you guys are on these.
Yeah, and it's one of them we may have the conflict off of as well. Just by my quick review of the complaint, I recognize the co-defendant.
Got it.
I think it's the same by Mr. Dukas is on all your other matters.
Yes.
How many are set for her tomorrow?
He's very impressive.
MATARNEH.
If I'm correct, the case number is 1311708, Your Honor.
It is.
Ms. Montane was the one person I did not get to speak to when I was running around during the first arraignment, so I apologize, Your Honor.
No, not a problem. It's been almost 10 years since we should.
Yes, Your Honor.
We may be able to take care of this quickly. Ma'am, where have you been?
I had a daughter, and then I was dealing with the domestic violence for 8 years, and now I'm finally getting my life together. Got a whole new relationship and new life, and I just inherited a large amount of money, so I could take care of my daughter now.
Cancel the bench warrant, I'll reset her bond to $5,000 personal assistance bond. I will set pretrial in this matter. Pardon? Or set pretrial April 15th, 2026, 9 a.m. or as your invite indicates. I will set her bond at the $5,000 personal recognizance. I will just reiterate the conditions of standard conditions, including no assault behavior, possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Yes.
I will also indicate at this time. Oh, all right. I will indicate also that at this time you're not to enter any Sam's Club in the state of Michigan. You understand that?
Yes.
All right. Thank you.
What do I do?
For TV, just call them so you can set up an arraignment.
If the court calls the
They can do that.
versus Harvey Ruda. Mr. Ruda, you are before the court on a felony complaint that alleges 3 counts. The complaint alleges that on or about September 3rd, 2025, at the location of 5301 Macaulay Drive, Superior Township, Washtenaw County, State of Michigan, count 1 is that you did carry a weapon concealed. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That's a felony, punishable by up to 5 years incarceration, a $2,500 fine plus court costs, and does require the mandatory forfeiture of any pistols, weapons, or device. You understand that, sir?
Yes, Your Honor.
The count 2 alleges that on that same date and at that same location that you did or were in possession of a firearm and that you are a person prohibited from possessing a firearm. Do you understand the nature of that charge?
Your Honor.
That's a felony, punished by up to 5 years incarceration, $5,000 fine plus court costs, mandatory forfeiture of the weapon or device. You understand that?
Your Honor.
Count 3 is a charge that on that same date and at that same location that you did possess ammunition and that you are a prohibited person from possessing ammunition. You understand that charge, sir?
Your Honor.
That's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs, and mandatory forfeiture of the weapon or device. Do you understand all of that?
Thanks.
First question I have for you, sir, is do you want to be represented by counsel?
No.
Pardon?
Can you say it again? Ask me again.
Do you want to be represented by an attorney?
Yes, sir.
This is public defender.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ruda. At the time, Your Honor, any mute as to the charges, and I'm prepared to address bond when appropriate.
Defendant, you waive any further formal reading.
Yes, I waive any formal reading. Thank you, Your Honor.
And defendant standing mute, court will enter not guilty to this charge. Probable cause conference in this matter will be set for April 9th. bond in this case? Anything from the people?
Yes, Judge, we'd asked to a no-go to the address that you had put on the record moments ago. We'd also ask for all standard bond conditions, including no assaultive behavior, stalking behavior, no firearms, ammo, components, or weapons, do not possess or use any devices for creating, manufacturing gun components, do not violate any criminal law, do not leave the state, no alcohol, marijuana, and drugs. And I don't know if he has any weapons currently, any firearms that need to be, that the court needs to know about, that need to be collected from this defendant, Judge.
No, Your Honor.
You don't have any weapons?
No. And, I'll be, I went to,
Mr.
We already went over that, sir. So,
Vukovich regarding bond.
yes, Your Honor. At this time, I'll be requesting a person with constant bond. Mr. Rueda has been in constant communication with my office. We do have good contact info. He does have gainful employment. However, he is taking a break from that due to a injury with his ribs. However, he was working at a barbershop, but unfortunately, due to the accident he was in, he must take a break from work. He is a father and a primary caretaker to 2 children who are 5 and 4. He also helps take care of his mother, who is 76 years of age. He does have another pending matter before Judge Sway, which he is on a tether, but has no violations. He's been in compliance the whole time while in front of Judge Sway, and he'll be starting to work again soon. At this time, I would be asking for a person with constant bond.
What's currently before Judge Slay?
I've been on tether for like 4 months.
Yeah, he has been on tether for at least 4 months, is what he's indicating to me.
Was there a case pending in September of 2025?
Interview sheet, he thought he was arrested for both of these cases since September, spent some time in jail, and then this case was later authorized.
So both cases happened at the same time?
Yeah,
Okay.
I believe both cases happened around the same time.
My old case,
Yes.
my old case is like 4 years old, 4 years old. The one I'm on tether,
The one that you,
and tether is like 3 or 4 years old.
Yes. So I think, okay, my understanding then is his other case is a bit older, but he was arrested, but he thought was at the same time for these 2 offenses. So I do not believe he was on bond at the time of this new alleged offense. I think he was arraigned on the 2023 case closer to the September 2025 date.
so he wasn't on bond at the time of this case?
That is my understanding, Your Honor.
Did the people dispute that, or?
Judge, I'm still, I can't even locate the name because I don't even know the spelling, and I don't have a list of.
His last name is Ruda, Rueda, Senior. It's Javier is his first name.
Judge, I'm sorry.
Was he on bond on his previous case, time of this offense? This offense occurred September 3rd of 2025.
Case. No, I was when I came to the new case at the hospital,
That's what.
I was not in bond. I just they arrested me for the old case.
Yeah, that's what that.
And on bond, and they charged me with a new case.
When you got,
4 weeks ago.
yeah, that's how I just explained to his honor.
So I was in the hospital when the new case happened. No,
Were you on parole?
no, I was a long time ago. I'm not. I ain't been on parole, probation, and then
I have here that the defendant was outside Trinity Hospital with a 3-year-old child. Called and reported that the defendant was actually actively overdosing while sitting on a bench. The police, upon searching him after attending to him, found his parole ID card as well as 7.75 grams of suspected cocaine, as well as 20 rounds of ammunition. So it appears to me not only was he in possession of firearm or weapon or ammunition at the time, but he was under the influence. That this offense was occurred, he was on warrant status for that previous CCW in circuit court.
Yes, Judge,
Right.
that's what I just wanted to say. That's what my notes are showing as well.
I'll order standard conditions, including no assaultive behavior, possession of any weapons or any stalking type of behavior. There's to be no alcohol, recreational marijuana, or any illegal drug. If he's on a tether out of circuit court, I'm not going to order a tether. I will indicate that the defendant is not to go to the 5301 Macaulay Drive address except for medical attention.
I'm just in the hospital or something. That's not believe me when I went back in there because I broke my ribs.
Yeah.
Oh, I can't go.
You can go for medical attention, is what you said.
Oh,
All right. I will, however, indicate that the defendant was on warrant status at the time that this was picked up. As further indicated, he was actively overdosing. So I think it's important to point out, not only was he in possession of these firearms and ammunition, but was so in possession of those with also the presence and actively using narcotics at the time. So therefore, the defendant's bond, I'm not going to grant a personal recognizance bond. I'm going to set the defendant's bond at a $5,000 cash or surety bond. So he'll need to post that prior to leaving. Go with my bail or something.
5,000.
5,000 cash or pardon? Yeah. Court calls the case People versus Ahmad Issa. Why are they on this? You should only be given whatever date is.
This was a felony review.
I know it gave, but I don't know why we're giving two different dates. We'll move that one. Ahmad Issa.
Sure.
Mr. Issa, you are before the court on a felony complaint it's a 2-count felony complaint that alleges that on or about March 7th, 2023 at the location of 3020 Washtenaw Avenue and also at 2190 West Michigan Avenue. Number one, that you did commit larceny in a building. Do you understand the nature of that charge, sir?
I do not.
Pardon?
I don't understand the nature.
Okay, here we go then. The complaint alleges that on March 7, 2023, at the location of 3020 Washtenaw Avenue, and I think also then there is a transaction which occurred at 2190 West Michigan Avenue. Count one alleges that on that date that you did commit larceny in a building, specifically states that you did commit the offense of larceny in a Crunch Fitness by stealing a credit card, cash, contrary to Michigan statutes. Do you understand now what you are charged with?
Yes.
That is a felony, punishable by up to 4 years incarceration, a $5,000 fine plus court costs. Do you understand the maximum penalty?
Yes.
Count two alleges that on that same date and at that same location, that you did knowingly retain and knowingly possess or knowingly secrete or knowingly use a financial transaction device without the consent of an Austin Bryant, the device holder. That is commonly known as stealing or retaining without consent a financial transaction device. Do you understand the nature of that charge?
Yes.
That is a felony, punishable by up to 4 years incarceration, a $5,000 fine plus court costs. Do you understand those maximum penalties?
Yes, Your Honor.
First question I have for you, if you want to be represented by an attorney. It's the public defender case.
Yes, Your Honor. Assistant Public Defendant Nick Bukovich on behalf of Mr. Issa. At this time, Your Honor, will waive any additional formal reading of the complaint, restanding non-proceedings as bond when appropriate.
Defendant having waived further reading, standing mute to the charge, court will enter a not guilty plea. I'll set probable cause conference in this matter for April 2nd, 2026, 9 a.m. Yes, ask anything from the people regarding bond.
Judge, we'd ask for a no contact with the victim and a no go to the address. We'd ask for all standard bond conditions, including no assaultive behavior, no stalking behavior, no firearms, ammo, or components. Do not violate any criminal law. Do not leave the state. No alcohol, no marijuana and drugs.
At this time, Your Honor, I would be requesting a personal conscience bond on my client's behalf. My client has no prior criminal history. He does work full-time doing medical sales. I would be requesting that he be able to return to Ohio. His primary residence is in Ohio. This is a slightly older offense, with alleged offense date in 2023. After conversations with my client, I believe we do have some strong possible offenses to it. As indicated again, he has no prior criminal history. He is here today purposely availing himself to the court to get this matter handled. He's driven about an hour and a half from Felony, Ohio to get here to get this warrant taken care of. So obviously he is showing that he takes this matter very seriously. And if I recall correctly from reading the bond form submitted by the prosecution, there was no objection to a conditional release without any cash components. So I believe a PR bond is appropriate.
Set the defendant's bond at a $5,000 personal recognizance bond. I will order all standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir? You understand that this time you are also not to possess or consume any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Sure.
I'm going to indicate that the defendant is not to go to 3020 Washtenaw or to the 2190 Michigan Avenue address. You understand that, sir?
Sure.
I will order that the defendant may return to Ohio to reside, but he must attend all court proceedings or places as directed by the court. You understand that?
Sure.
Right. Thank you.
Thank you. Okay. Can you repeat that court date one more time, Your Honor?
Court date?
Yes.
April 2nd.
April 2nd. Thank you.
Thank you.
Thank you, Your Honor. Appreciate it.
Court calls the case People versus Diamond Byers. Oh, there she is.
Yes.
Hello, what's your name?
Hello, Diamond Buyers.
All right, ma'am, you are here before the court on an arraignment on two felony, they're both felonies, right? Yes, two felony complaints. First one, that being 26 FB 1025, that complaint alleges that on or about December 17, 2025, at the location of 3020 Washtenaw Avenue, that you did knowingly retain, possess, or secrete a financial transaction device without the consent of the owner. Do you understand the nature of that charge, ma'am?
Yes.
That's a felony punishable by up to 4 years incarceration, a $5,000 fine plus court costs. You understand that?
Yes.
Is that a yes?
Yes, I'm sorry.
The other case, that being 126F 0190, alleges that on or about August 10th, 2025, at the location of 2723 Oak Valley Drive, Pittsfield Township, that on that date you did knowingly retain without the consent of the owner of a financial transaction device. Do you understand the nature of that charge?
Yes.
That's also a felony punishable by up to 4 years incarceration and or a $5,000 fine plus court cost. You understand that? First question I have for you on both of these matters: do you wish to be represented by the public defender? These are public defender cases. Go ahead, Mr. Buncher.
Yes, Your Honor. Assistant Public Defender Nick Buckovich on behalf of Ms. Byers in both matters. As it relates to a formal reading, we will waive any further formal reading in both matters. We'll be standing mute, and I'm prepared to address bond when appropriate.
Defendant able to waive formal reading, standing mute. Court will enter a not guilty plea. I will set probable cause conferences in these matters for April 2nd, 2026, 9 a.m. Any issue regarding bond from the people?
Judge, I would just ask for a no-go to the 3020 Washtenaw Avenue address on the first case, and then the 2723 Oak Rally address on the second case. And then we would ask for all standard bond conditions, including no assault.
Byers is currently a nursing student. She also does work full-time as a caregiver. She is local to the area, so she's not a flight risk. When she was made aware of these warrants by Mr. Drukas, who's representing her in another matter that'll be before Your Honor tomorrow, she came very quickly to take care of these matters. There's even a misdemeanor warrant that she's already paid the bond on, showing that she takes these matters very seriously and she's trying to resolve all her outstanding matters. So at this time, Your Honor, I would request a personal accountant's bond in both matters. I believe there be no issues of no contacts and no go-tos in any matter.
Wasn't on bond at the time of these offenses, for sure. See, you said she had something else before
From
on the warrant status when these occurred? I mean, because you said she has other cases.
Yeah, I had a misdemeanor warrant for retail fraud that I paid the $1,000 today for when I walked in, and then Edward said,
When did that warrant, you see it? I got that. What's the date of that? Yeah, well, the date of the warrant.
December 17th, 2021.
also was showing up for all my other court dates during that time.
yeah,
Together.
yeah, my client has indicated that she has been paying all to all of other court dates at a time. That Mr. Dukas was doing this so we can consolidate all the cases and get everything on the same track.
Anything else from the people?
No.
Set the defendant's bond in each of these cases at a $5,000 personal recognizance. In each case, I will order standard conditions, including no assaultive behavior, no possession of any weapons, ammunition, or anything fashioned to be a weapon. I will order also no alcohol, recreational marijuana, or illegal drug use. You understand all of that, ma'am?
Yes.
In the case ending in 1025, I will order you to have no contact with Ryan Coons. And you are not to go to 3020 Washington Avenue. You understand that? In the other case, I will order that you're to have no contact with Renee Price, and you are not to go to the 2723 Oak Valley Drive address. You understand that? All right. Thank you.
Thank you. So I still show up to court tomorrow? For good.
Yes.
Okay. All right. Thank you.
Well,
She has cases tomorrow.
I believe she has a PCC tomorrow. Yes. She wanted me
Hold on a
to.
second. I didn't understand what you were telling me. Come back up, man.
Yeah, they're yes.
You were trying to get them all together, correct?
Yes, if possible. I did speak to her. I did understand if you can't get them on the docket tomorrow with such short notice, and we did speak about that. Correct, Ms. Byers?
Correct. Yes.
I mean, I will set them. I mean, you guys are on these.
Yeah, and
So-
it's one of them we may have the conflict off of as well. Just by my quick review of the complaint, I recognize the co-defendant.
Got it.
I think it's the same
Um,
by Mr. Dukas is on all your other matters.
Yes.
How many are set for her tomorrow?
3 year on all insurance.
Okay, I'll tell you what, let me reset these tomorrow. Let's try to get everything together.
Yes, please.
So I'll set these for tomorrow, so she'll have all of those. And Mr. Bukovich, if we can try to get approval on the conflict and see if we can get that resolved so we can get her.
Yeah, as soon as I'm out here, Your Honor, I'll try to get it done for you today.
I know you will take care of it. So 326, I'll set your probable cause conference for then tomorrow on
Okay.
this case. It's
Great.
all together. All right.
Okay, how you want it?
All right. Okay.
No problem. Have the rest of the day.
Court does call the case. Zonaida Javiera here. Javiera, not present. I will, in each of these cases, then issue warrants for the defendant's failure to appear. Bond it will be set in the amount of $5,000. I'll give a 10% privilege. Those warrants will issue immediately. All right, I think that's all I have.
Yes, sir.
All right, that's it. Ms. Woods, thank you very much.
And then Judge, I'm back at 1:30, correct, for the afternoon arraignments?
You're back
Or, I'm
at
sorry,
1:30?
1
You're
o'clock?
gonna come bother me at 1:32?
Going to the top right picture, what is that?
That is the left driver's side frame, the hole you see right there is where the cross member, the left cross member which connect to that hole right there to the frame. You see, I don't know how good this picture is, you guys, but cross member supposed to go in that hole right there. But got snapped off.
And how about the bottom left picture? What is that?
I had my driver's side and left side.
Okay. Now, the condition of your vehicle in these pictures, is this the same condition that it was prior to the crash aside from the damage?
This is no,
Was there any work done in between the crash and when these pictures were taken, to your knowledge?
like,
In between the crash and when these photographs were taken, was there any work done on the vehicle?
yes.
What work was done on the vehicle between?
Someone happened to crash, right?
So the crash occurred, and at some point these photographs were taken.
Yeah.
In,
Oh, no, there wasn't, I'm sorry.
okay. Do you remember when these photographs were taken?
The day of the accident would be June 13th.
Did you ever seek to get the damage repaired?
After that, yeah, I mean, I plan on getting it repaired after the accident occurred.
All right. What did you do in order to get the damages repaired? Who did you talk to?
Well, first I had to make a claim for my insurance company. Damage was, the insurance takes a little while to do. So I had to, that's too free, I can,
What was the
Why didn't the insurance cover all the damage?
Well, I mean, I did have full coverage, and so the estimate, they gave me, I mean, based on the prices and those are like auto body shops and like that wasn't generally covered. So I guess because it's 2007, they don't want to cover the whole expenses, Your Honor.
Because they really totaled it out but let you keep the vehicle.
Yeah, good.
Yeah, that's exactly what they did. Okay, go ahead.
Okay. Sir, did you ever take this to an auto shop for repair?
Yeah, I did.
Which auto shop?
It's what?
Does the name A2 Auto Group mean anything to you?
Yeah.
And when you went to that auto shop, was it for these damages or for something else? Did they ever provide you with any estimates or invoices related to these repairs?
Yes.
And what specifically did you have them try and repair, or did you ask them to repair?
Well, the first job, this is for my safety because it's my vehicle. I need to get the cost. I was connected to the second picture on the top, the right side. That's where the crossing is connected to. It was dangling there about 3 years. So I need to keep that for something else causing more severe damages.
I'm showing defense counsel has been marked as People's Proposed Exhibit 3. I apologize, I'm going a little bit out of order here. May I approach the witness?
Man,
Sir, I'm handing you what's been marked as People's Proposed Exhibit 3. Can you please take a look at that document and let me know if you recognize it?
Yes, I do.
What is that document?
That was the first job I had to get done for my GMT there, the cross member job.
And this document, but what specifically is the document?
It's showing the receipts and the cash of the money that I had to pay to get it fixed.
And is this a fair and accurate copy of that invoice or receipt? Are people move to admit what's been marked as People's Proposed Exhibit number 3?
no, there. Exhibit 3,
I have a copy for the court. The court would like that as well. May I approach?
yes.
Thank you. And so, sir, looking at this document on the right-hand side near the top, there's some columns that say labor and description, and then on the left-hand side it says part and description. What is that, or what was being serviced?
So the cross member needed to be the reverse full cross member versus the piece was connected to the frame. That needed to be placed because it was basically broke off, snapped off.
And then where it says total and balance due, it says total, I believe, is 1,200 and balance due is 0. What does that mean?
So that means that's pretty much the cost and labor for the job.
I guess what's the difference between those two lines? Do you know?
So still in the total 1,200. I don't think there is no difference. To be honest, it's just I think the mechanic wanted to just all shout itself together as one. What I'm saying?
Was there a problem with your cross member before this? Was there a problem with their cross member before this? Accident.
When I got a year prior before the accident, it was perfectly underlined. It was, like I said, the truck came from a dealership saying I'm still paying for it. I mean, the truck was in mint condition. It was a nice truck, besides a little bit of rust. But it's pretty common for Michigan vehicles.
Fine.
Thank you. And so, sir, how much was paid out of pocket to replace that cross member?
Well,
I'm showing defense counsel was marked as proposed exhibit number 6. May I approach the witness? From here, people proposed exhibit number 6. Do you recognize this document? And what is that?
That is the main receipt we received from the bottom again.
Is that a fair and accurate copy of that receipt for that invoice?
Yes, it is.
People are moved to move to March to propose exhibit 6 into evidence.
Any objection?
No, Your Honor.
Exhibit 6, admitted.
May I publish to the court?
Thank you.
And so, sir, who actually paid this $1,200?
Fiance.
Other than that cross member, what other repairs did you get done?
Yeah, well, the pictures right here from the first pictures, the body needed to be done, and then the driver's side cab needed to be replaced. Yeah,
Did you ever get an estimate for how much it would cost to get that done?
after calling around, that's why I came to the conclusion of H2 Auto. He was the cheapest one, and the estimate was, well, it was about almost $5,000.
How many different auto shops or dealerships did you speak to in order to get an estimate for these repairs?
Insurance, two of them, they recommended for me to reach out to see how much they would charge, and they said it was too out of my price range. It was too expensive.
Do you remember how much the estimate was for those two that your insurance recommended?
It was, the first one, I think, when I first reached out to the first one, they said it's gonna take about over a month to repair the damages, you know what I'm saying? And I can't really tell you the bottom dollar how much I know it was a lot more than what we could manage.
So you got no written
witness.
no written estimates from these other places?
No.
Go ahead.
I'm showing defense counsel's marked as people's proposed exhibit 2. May I approach the witness?
You may.
Sir, I'm handing you what's been marked as people's proposed exhibit 2. Do you recognize this document?
Yes, I do.
What is it?
This is all the breakdown of what it took to replace the cab. Sarah.
And is this so is it fair to say this is an estimate for that repair? And is this a fair and accurate copy of the estimate that you got from A2 Auto Group as it relates to these damages?
Sir.
People move to admit what's been marked as people's proposed exhibit 2 into evidence.
No, Your Honor.
Exhibit admitted. Thank you. That's, yeah.
So, sir, looking at this, what was the estimate from A Auto Group for the repair to the cab and the body?
Well, after I told him what the insurance was going to give me to cover the difference, he told me if you would probably an additional $3,000 to do the job.
What was the quote from the dealership for how much it would cost to repair your vehicle's damage for the body, not the cross member, just the body?
Body. So his quote was 49.
Is that the 49.39 cents on page 2? Okay. And of that, how much did you say your insurance would cover?
The insurance, I believe they 19. What 1988?
So I've shown defense counsel's marked as people's proposed exhibit 4. May I approach the witness?
You may.
So I'm handing you what's been marked as people's proposed exhibit 4. Do you recognize that document?
Yes.
What is it?
So this is more of a better number, more of the facts. The insurance check was 1932 for my insurance.
But what is this document?
Yeah, sorry. This is the document showing what the insurance was gonna get, well, they was covering me for my truck.
And is this a fair and accurate copy of that letter from your insurance?
Yes.
People move to admit what's been marked as people's proposed exhibit 4 into evidence.
Any objection?
No, Your Honor.
Exhibit 4 is admitted. But they paid that check to you, didn't they?
Yes, they did.
May I approach to publish the report?
Yes.
So, sir, the amount of that check that Progressive gave to you, is that the total payment amount on this document, that 1932?
Yes.
All right. And so when we take the estimate of the 49.39.64 from, that would be people's 2. How did that 1932 go towards the $4,900 estimate?
Yeah, so that's the candidate.
And so how much did you end up actually paying out of pocket for those repairs?
I think it's just a body job, not the cost of it was $3,000.
I'm showing defense counsel's marked people's proposed exhibit 5. If I may approach the witness.
May.
Sir, I'm handing you people's proposed exhibit 5. Do you recognize that document?
Yes, I do.
What is it?
This is the receipt the mechanic gave me for the job, for the cab job.
And is this a fair and accurate copy of that receipt for the repairs for the body damage? People move to omit what's been marked as People's Proposed Exhibit 5 into evidence.
Admitted.
Permission to publish?
Yes.
So, sir, you paid, or who paid the actual $3,000 on this receipt?
Yes.
So in total, that makes the total payments from your fiance how much?
With the cross member, it came to about 4,200.
Other than the A2 auto group and the two insurance recommended mechanics, was there anyone else that you spoke to about getting these repaired?
No, but I do, can I say this? I do know this much, that the ones they recommended was more money than what I'm at from this
Okay.
shop. Let me out of pocket.
So how much total are you requesting in restitution?
I just want, I guess, prepare.
All right, pass the witness at this time.
What are you considering fair?
So my truck, as of today, Your Honor, is fine. My truck is good. You know what I'm saying? So I'm happy with that, but it's a struggle with me and my fiance. We all have our struggles, and it takes a lot out of our savings to do, fix my truck. So, I mean, on behalf of her part, that's why I'm here today. I mean, if you ask my fiance, she wants the whole amount what she out of pocket back. But I'm not a greedy man, I mean, I just, that's why I come down to the conclusion.
What are you considering to be fair then, sir?
I'll be happy if I just, okay, so I missed 3 days of my job coming here, so, I mean, fair, I mean, I just say, I ain't trying to get everybody, I mean, it's a struggle for everybody on it,
I understand that, but what are you considering fair? I'm trying to clarify the last answer you gave.
I think fair would be at least the body job, the 3,000 for the body.
Cross-examination.
Thank you, Your Honor. Good morning, sir.
Morning.
I'm going to remain seated here, so if there's anything you can't hear me say or don't understand, just let me know and I'll speak up and try to clarify myself, okay?
Okay.
So you testified that when you reached out to your insurance, technically they totaled your truck, correct?
They gave me the option to total it.
Okay. Versus getting it fixed?
Yeah, just the fact because I was still paying for this truck on my dealership.
Okay. And you said you have full coverage, correct?
Yes, sir.
So if you have full coverage, wouldn't that mean that your insurance would cover the rest of these repairs outside of your deductible?
In my opinion, from my experience, that's just insurance being insurance.
Okay, but you have $1,000 deductible on your insurance policy?
Yes.
Did you pay that $1,000?
I think that's what they took away from the check they gave already. That's minus deductible.
So basically, they totaled your truck out for $2,932.19 and subtracted your deductible from it. Is that what you're saying?
I think in a way, I think so, yeah.
Okay, so they did.
Well, you think so. That's what they did, isn't it? They gave you the option to total it,
Yeah,
which means they would take the truck and pay you money,
yeah.
but they didn't do that.
Yeah, because Your Honor, my opinion, my truck's worth more than what they was gonna
I
drive.
understand what your opinion might be, but I'm just trying to get a clarification on what your insurance company did. Insurance company did is they gave you the option. They paid what they would pay, which was basically $2,900. Took your deductible of $1,000. You got to keep the truck and whatever that was worth, and they gave you money.
I think so, yeah. Yep.
Okay, go ahead, Mr.
Thank you, Your Honor. And sir, I want to make sure this accident happened on June 13th, 2025, correct?
Yes, sir.
Okay. And did you get any estimates before you reached out to your insurance?
No,
So How, do you know how they came up with the number of what your truck was worth then?
Honestly, I don't know how they came up with that number.
Okay. And you were shown a couple exhibits here. One was a document you provided from Progressive, correct?
Yes.
And that document is dated June 25th, 2025.
Are we looking at people?
The Progressive of document.
Oh, yes.
Yes, June 25th, yep.
Okay. And so this accident occurred on June 13th, 2025, correct? So 10 days later, you had essentially resolved this issue with your insurance, correct? And how many vehicles do you own that you drive?
Just the one, sir.
Just the one truck? And with a broken cross member, is the vehicle drivable?
It's not safe to drive, the broken cross member.
Okay. Yet you waited, and it looks like, and I don't have the exact exhibit number, but the date of the estimate for the cross member, that's dated July 12th, correct?
Yes.
So you waited after the insurance paid you out, you waited an additional 2 to 3 weeks to have your vehicle checked out.
The vehicle was posted.
Okay, so you didn't drive for 2 or 3 weeks?
That was a cross member.
Okay. But again, it sat there after you received the insurance check, correct?
Yes, sir.
Okay. And then even later, and I just want to find the date here, I believe it is July 17th, that's when you got the quote for the body repair. Correct?
I sent you.
It's I don't know the number, that might be the 4,900.
That's people's two.
Do you see that date on that, sir?
On the 49 page?
Yes, sir.
Oh, yeah, okay.
Okay. So July 17th is when you got that estimate, correct? Nearly a month after the accident and after insurance had paid you out on this, correct?
Yes, sir.
And you're saying you did not drive that truck that entire time?
No.
Okay. Why did you wait so long?
Oh, I mean, it was a job, you know, and we saved, we tried to get a house and it's a lot going on and we just had to manage what was the insurance was gonna cover and, you know.
And again, insurance had basically said this truck is not worth any more than the 2,900, right?
They did not say that, they did not say it's not worth that. They did the option. They insured, they don't want to truck.
And your insurance, similar to a medical provider, correct? They have repair shops that they choose to work with,
My insurance did, yes.
and you chose not to work with any of the shops that your insurance works with, correct?
Yes, correct, based on these receipts, these numbers on the receipts would have been a lot more than, you know, it is if I would have went to the insurance.
But if you, so you have full coverage, and if you would have chosen not to total your truck, your insurance would have covered the entire thing, correct?
But if that's one of the truck, I would have gotten it, like, put it in the truck.
But you did total the truck, that's why they sent you the check. That's why you didn't have to pay your deductible.
They gave me the truck to fix the damages based on what, you know.
But you never paid that $1,000 deductible, did you?
They added that deductible to the 1,900.
Right, so they subtracted it from essentially 2,900, so you never actually paid them, correct?
Insurance?
Correct.
I never paid insurance.
Right, so if your insurance would have covered the repairs, how that works, and correct me if I'm wrong, but you pay that $1,000 and they cover the rest, that's the point of full coverage, correct?
For the $1,000 deductible, right?
Yes, you would pay the $1,000 of either to your insurance or to the repair shop as your portion of deductible. The insurance company would pay the repair shop the rest, correct?
Yeah, so with the 1,900 again, yeah, like you were saying, that's with the 1,000 deductible. So it's like you said, it was like 29.
No, I think you're misunderstanding me, sir. If you had paid that deductible, your insurance company is Progressive, they would have paid A2 Auto Group or whichever auto group you had chosen to go through, correct?
They would have paid a little bit, they would have paid, the 19.
But you did choose to total your car.
No, yeah, I mean, I think it actually fallen in total,
Okay.
but I'm still, like I said, the truck's got a lot of life into it,
Oh, I understand that.
and for record, these trucks, based on facts, they go up to 500,000 miles, and my truck's only barely at 119. The truck's got a long life ahead of it.
Okay, and it's a 2007?
Yeah, but a lot of 2007 trucks are really nice, inexpensive.
So what was your insurance company put a value on that vehicle, right?
The insurance,
They would have paid you a certain dollar amount, but taken the truck.
well, like, I mean, I feel like it wasn't justified for the insurance.
I'm not asking what you feel. What your insurance company said is we would give you 2,900 for the truck. That's really what they said to you.
Instead of giving me the check, right?
Well, they would have given you 2,900 and taken the truck, right?
I believe so.
Okay. And so what they did, and they gave you the other option that they gave you was, okay, you're going to keep the truck. You need to pay your deductible. We'll give you the balance. And that's where the 1,900 some odd comes from, right? So at the time of the accident, your insurance company had valued that truck at $2,900, basically $3,000, $2,900.
To the insurance perspective, yes.
That's what they valued the truck. Okay. You don't have any further questions, do you?
No, you're all right.
Good. Any redirect?
No, Your Honor, thank you.
Thank you. You may step down.
Now, people have no.
In this courtroom moment, the judge pauses the proceedings after realizing there may have been some confusion about scheduling multiple cases. The judge calls the woman back to the front and calmly asks her to clarify what she was trying to explain earlier. It quickly becomes clear that the situation isn't simple. Several cases and defendants are involved, and the court is trying to coordinate them all within a tight schedule. The woman explains that she attempted to organize everything together, but with such short notice, it has been nearly impossible to get everyone present or properly scheduled. The judge listens carefully and asks whether the parties were able to speak about the issue beforehand. She confirms that they did discuss the problem and that arranging everything for the next day would be extremely difficult because doctors, attorneys, and other obligations were already scheduled. At that point, the judge reviews the complaint more closely and recognizes that one of the co-defendants is someone the court has seen in other related matters. That recognition raises another concern: possible scheduling conflicts involving attorneys who may already be handling multiple cases connected to the same people. Instead of forcing a rushed decision, the judge begins asking practical questions. How many hearings are scheduled for the next day? Which defendants are involved? And whether the same attorney might be representing several of them. The judge makes it clear that the court wants the cases handled properly, but also understands that organizing multiple defendants, attorneys, and court appearances at the same time can be complicated. Courts often have to balance efficiency with fairness, making sure everyone has the opportunity to appear and be represented correctly. This moment shows how courtroom proceedings aren't always dramatic arguments. Sometimes the biggest challenge is simply managing the logistics of multiple cases and people involved. And it raises an interesting question. When several defendants and attorneys are tied to the same case, should the court move forward quickly to keep the schedule on track, or take extra time to make sure everything is properly organized?